Please be seated. Court now calls case number CV1383, Davis versus BNSF Railway Company. This is the time set for oral argument. Counsel, as you know, these proceedings are being audio and video recorded. And you perhaps don't know this, there's a link for these proceedings to the court website. So within a few days, this will be up on the court's website. When you present your case, please identify yourself and your client. As you know, you both have 20 minutes to present your argument. Appellant, you can reserve some time for rebuttal. We've read your briefs, we've discussed the case, so we're very familiar with the issues. You have a clock on the podium in front of you to keep track of time. Counsel?
Good morning, Your Honors. Thank you for having us today to do oral argument. May it please the court, my name is Jason Romero. I'm appearing on behalf of plaintiff appellant Wes Davis. With me today is co-counsel Anthony Petru. I would like to reserve, if possible, 5 minutes of my time for rebuttal. As the court has already noted, the court is familiar with the briefs, has read the briefs, and familiar with the issues in this case. So I won't belabor things that I think we've already gone over well in the brief, but I certainly want to answer any questions that the court may have. What I will say is that we're here essentially on a single issue, and the issue is whether the 95% contributory fault or comparative fault finding and allocation by the jury in this case was supported by any evidence in the record. As an initial matter, was there sufficient evidence to submit that issue to the jury in the first place? And even if there was, having submitted it, was there sufficient evidence to support the finding by the jury of 95% comparative fault? Essentially, the facts relating to the accident itself are not in dispute. What occurred here is pretty clear from the record and undisputed. Mr. Davis was a conductor operating a train heading eastbound into Winslow, Arizona. He was stopped at a signal outside of west of Winslow, waiting on traffic, essentially. As a result of being stopped on the main line, there are two main lines that run parallel to one another, one typically going east, the other typically going west, although not always. Mr. Davis, one of his job duties was, if he was stopped on a train as the conductor and another train was passing on a parallel track, he was required to get down off of his train and conduct a roll-by inspection, which is a visual inspection of the undercarriage of the train. As they were stopped at the signal, it became clear that a train would be approaching and that they would have to conduct this inspection. Mr. Davis proceeded to disembark the train in the manner in which he was taught, according to the rules that BNSF enforces. He maintained a three-point stance, or three-point contact, which means you're always going to have two hands.
Let me
Sure.
stop you. I appreciate that. We're familiar with the facts of the case. The standard for the court giving a jury instruction is pretty low. I want to cite the Budinsky case because I wanted to say Budinsky today during this oral argument. But
Sure, Your Honor.
it doesn't take much to get a jury instruction on comparative fault, does it?
The standard is low to get a jury instruction, but there has to be some evidence. And in the FELA context, the FELA context, the case law is clear that that evidence has to be simply more than maybe the jury won't believe the plaintiff here. There has to be some affirmative evidence adduced by the defendant. In fact, one of the cases, I believe it may be the Taylor case, I'll make sure I get the site right for you, puts it this way. Essentially, you've got this shifting burden. Plaintiff has a burden under the FELA to prove, by preponderance of the evidence, that the defendant railroad was negligent. The defendant railroad has a similar burden to prove by preponderance of the evidence that there was negligence on part of the plaintiff that contributed to his fault. The defendant railroad cannot simply stand on the fact that the accident happened, therefore plaintiff must have been negligent. There simply must be more, and we posit that in this case there wasn't.
Right. Now, but preponderance of the evidence, that's not the burden for getting an instruction on it. I know you're arguing on two levels here. One, the
Certainly.
instruction shouldn't have been given. There was no evidence to support instruction, and the sufficiency of the evidence in support of the comparative fault finding.
That's correct, Your Honor. And my only reason for raising that issue was simply to say that there has to be some evidence. I agree that the burden is low to give the instruction, but there is a burden. You must adduce some evidence. What we see from this trial record and what occurred in this trial was there was no evidence adduced of contributory negligence, of comparative fault. There was none pointed to by counsel during closing argument. Surely had there been some adduced, there would have been some evidence raised for the jury to look at.
But at trial, plaintiff agreed to an instruction, even proposed one, if I recall, that included reference to plaintiff's negligence.
Well, thank you, Your Honor. In fact, what happened at trial is plaintiff and defendant proposed competing instructions with respect to fault. Those were proposed, obviously, before trial had occurred. The trial court in this case, as trial went along, as we're getting to the end of the trial, suggested that he had selected those jury instructions which the court was going to use in this case, and then offered to essentially allow the parties to make a record. Plaintiff did make a record at that time, and what plaintiff said was, I notice in here that you've given a comparative fault finding. We had offered a fault jury instruction that would not include comparative fault. We don't believe it would be appropriate in this case to include a comparative fault instruction. And then counsel provided reasons. The first reason being essentially the reason that must be the support. There's no evidence to support it. But counsel didn't stop and stand on just the fact that there's no evidence. Counsel also drew the court's attention to the fact that there's substantial evidence to the contrary, showing that numerous individuals from the railroad had testified that there were no rules violations in this case.
Right, but then ultimately the instruction proposed included a reference to plaintiff's negligence. It wasn't the classic contributory or comparative fault instruction, but it was one that mentioned plaintiff's negligence in a context that the jury could consider, wasn't it?
That's true, Your Honor, over plaintiff's objection, sure. Once plaintiff had registered his objection, and understanding the necessities of trial, the parties were trying to get this done in time for the jury to come back and finish the case. The court essentially said, these are the instructions, but you can make a record on them. Counsel made a record. Once the court essentially overruled his objection, then counsel said, okay, well, if you're going to, under the circumstances that you're going to provide this instruction, let's make sure we get it right. And then counsel suggested language that would make sure the law was appropriate.
But now isn't this an accurate quote from the transcript that plaintiff's counsel said, I wouldn't have any objection to this if you find from the evidence that any negligence on the part of BNSF Railway Company or plaintiff contributed in any way or manner towards injury, etc. I mean, that's specifically saying plaintiff had no objection to that instruction.
Your Honor, it is, but read in the context of the entire discussion, it was after plaintiff had lodged his objection to a comparative fault instruction being given at all.
Sort of sounds like, well, that was our theory, but really we wouldn't object if you're going to do this. If in fact you said there was no objection to what was given, are we looking for fundamental error here then? I mean, we can still review, I suppose, for structural error or fundamental error, although I'm not sure we do that much in civil cases.
Let me answer. There's a couple questions there. First, Your Honor, I think what I understand the premise of your question to be is if the court finds, we certainly don't concede, but if the court finds that there was no objection to the jury instructions in this case, would the court be looking for fundamental error? And I think that's essentially the standard. It certainly is the standard that the court would apply when looking to see whether the evidence supported the verdict. I think it is applied in civil cases, maybe more rarely than in criminal cases, but certainly it has been applied, and we've cited the case law where that's been done. And in which case, essentially, it's difficult to understand how the construct is much different in terms of looking at this issue. If there's no evidence there, then likely the jury should not have received the issue at all, but certainly the jury was not supported in finding the comparative fault that it found. And so whether it's on the premise that the jury instruction should not have been provided or that there's fundamental error because the jury finding was unsupported by the record.
But I mean, as far as no evidence, that's one thing, but if there's any evidence from which an inference can be drawn of plaintiff's negligence, that would seem to be all that's required. And if I recall, the injury happened here when the plaintiff grabbed the other train, right?
Oh, no, Your Honor, no. The injury occurred here as the plaintiff was disembarking from his own train.
Right.
He was on the opposite side of his own track from the oncoming train, if you will. And what occurred essentially here, and there's no dispute, there's no contrary evidence, the plaintiff turned, he had firmly planted his feet on the ground. He was on a sloped mainline ballast, which is just rock, essentially. Far too much trial testimony about what it was. As he turned to walk essentially 3 to 4 feet down the slope ballast to a flat piece of land to conduct his inspection, the ballast gave way underneath his foot, causing him to twist, fall, and pop his ankle. There wasn't a lot in the briefing about the injury itself. The injury was very significant. He had multiple surgeries. There was testimony that he would require an ankle fusion in the future. He's certainly disabled from his work.
But getting back to Judge Thompson's question, the evidence in the record is basically Mr. Davis's testimony, right?
With respect to exactly what happened as he fell correct.
Right.
There is also supporting evidence from the engineer who did not see him fall but heard the accident occur. Correct.
Okay, but so from that evidence, there are multiple inferences to be drawn, aren't there?
I don't believe so, Your Honor. The evidence was pretty straightforward that he turned, he walked, and he
counsel,
fell.
By turning, has he necessarily avoided a finding of negligence? By turning, couldn't the jury find that the turning itself was negligent?
Well, I guess how I would answer your question is to look at the differences between contributory negligence and I guess what it seems like we're butting up against here, which is assumption of the risk.
No. Counsel, not that. Let me.
Yeah, sure.
Let me try to approach it in this fashion. Everybody knows there was a fall. A person can fall negligently because they trip and they're not paying attention, or a person can fall and there's nothing. It's not their fault. There's a lot of different reasons why a person can fall. Now, there was a lot of testimony in this case that conductors like your client were trained on how to walk on the ballast. It's something they had to do every day. I think your client testified he did it hundreds of times. So, but this was a very specific thing. They were trained how to walk on it. There were videos presented to the jury about you can walk on it, and this is how you're supposed to handle it. And I'm not certainly arguing what's the better inference, but the jury could have taken the way your client reacted to the movement of the ballast as consistent with his training and a proper way to handle an occurrence that they faced all the time of this moving rock, or he didn't follow his training and he handled it negligently. He twisted and turned and grabbed and reached for the train, and that's not what you're supposed to do. You're supposed to handle it in a different fashion. Now, again, if I were sitting on that jury, what I might have thought is one thing, but there are different inferences that the jury could reach about your client's own description of it, right? I mean, and is this court supposed to step in and say, no, we don't agree with that inference as being reasonable? The very fact that there is another inference means that there's sufficient evidence for the jury to base its verdict on, isn't there? Loaded question, I know. But you understand what I'm getting at?
I do understand what you're getting at, Your Honor, and I guess I would answer initially, certainly inferences can be drawn from almost anything. I don't think the standard is so low that the jury is allowed to draw any inference it wants without any evidence to support it. The standard is that there has to actually be some evidence, and the evidence to support contributory negligence is that the plaintiff did something which added to his danger. It wasn't simply that he showed up for work that day and accepted the risks of ballast sliding out from underneath his feet, which is clear the jury understood.
That's not the question. The question is, was it negligent for him to turn around and try and grab the train? Not assuming the risk, but was it negligent for him to turn around and try and grab the train as opposed to proceeding straight with the movement of the rock?
As he was falling. And what I would say there is there was no evidence that he was trained to do anything different than that. There was no evidence that he was trained what to do as his body was falling, essentially. We're not talking about something where he did that before he fell. It was all as one movement. He was falling and he tried to prevent. And maybe this is another way to say it. Wouldn't we be here arguing essentially the same thing if instead he tried to essentially surf down the ballast, hurt himself doing that, and the railroad could then say, well, why didn't he just turn and try to catch himself? He shouldn't have fallen. The truth of the matter is, number one, they didn't say that at trial. There was no argument to that effect at trial. The only argument to the effect of contributory negligence at trial was, well, he must have lost focus. It's conclusory. It doesn't cite any evidence. It doesn't really tell us a whole lot about anything. It certainly doesn't support any inferences. Certainly, inferences can be drawn without any evidentiary support. Here, the standard is higher than that, which is there has to be some evidentiary support for the inference that jury is drawing. It can't simply be, essentially that's the argument, we don't believe you. We think you did it wrong. You say you did it right and by the rules, we think not.
Wouldn't they be believing?
They would not be believing that he was, I guess that he was following the rules and his training.
Which rules specifically?
Well, the only rule that governed this was the 3-point contact rule and walking carefully on the ballast.
Mm-hmm. So they could have believed everything he said, but interpreted his actions as inconsistent with that 3-point contact rule, couldn't they?
I don't know that they could have interpreted it as inconsistent with the 3-point contact, because the 3-point contract is for disembarking the train. Once you've disembarked the train, at some point you have to let go and move to wherever it is you're going. So I don't know that they could have interpreted it that way.
Then couldn't they have believed everything he said and concluded that, based on his characterization, he was partially at fault for the accident?
I mean, I guess they could have made that. I guess I'm not conceding that that's an appropriate inference.
Here's the way I'm thinking about it.
Sure.
I don't disbelieve anything he said. I'm not questioning his credibility, but as I look at what he said, I can see different ways of visualizing it, different ways of interpreting those actions as reasonable or unreasonable. Is that incorrect?
I don't know exactly how you can interpret a person falling as unreasonable. I mean, it's one of those almost involuntary actions. You're trying to prevent yourself from suffering damage as the fall is occurring. I understand Your Honor's question. Certainly you can.
I agree. The inference against him may be a harsh one, and it may not be one I would draw.
I don't think it's one.
Whether it's possible.
I think this is one of those. I've walked you to the edge of the pier. Will you jump? I don't know if it's possible. The jury may have done that. I don't think it's supported by any evidence. I think it's contrary to the evidence in this case, and I think that
it's like walking on a bowling alley. I mean, maybe the wrong thing to do is to twist and turn quickly on a slippery bowling alley if you start to lose your balance. Maybe the correct thing to do is to make sure you keep your feet steady. And a jury, same way here, they can look at this. This is his workplace. It's ballast, it moves. He's trained to handle it in a certain fashion, and they viewed it as his quick twisting movement was the wrong thing to do, and that's what caused his fall. Whether I agree with that conclusion or not, or whether I would feel more inclined to believe he didn't want to hit his head on the rock, like you point out in the briefs.
right.
But I don't get to choose which is the reasonable inference.
Yeah, I agree with your statement. I think there was an underlying assumption that there was some evidence to the jury that there was training that he shouldn't have done it this way. There simply isn't any evidence in the record from which the jury could have.
There was training about they were trained to walk on the ballast and that it moved.
Well, there was evidence from a video, and I know I'm running into my reserve time. Hopefully I'll get to reserve a bit. There was evidence from a video, which there was also evidence that was never shown to Mr. Davis. The video says, here's how you walk safely on ballast. There was no evidence in the record that anybody had trained Mr. Davis on that. That video was shown for the purpose of showing notice of the hazards of the ballast.
But he did walk on the ballast a lot, and he was aware that it would move.
He was aware that it could shift underfoot, sure.
So, I mean, he had some experience about how to walk on it and how not to walk on it. A juror could conclude, right?
That he had that experience, yes, Your Honor. I'd like to, if possible, reserve the rest of my time.
Of course.
Thank you.
Counsel?
May it please the court, my name is Bill Thorpe. I'm here on behalf of BNSF Railway Company.
With me is co-counsel Brad Schwer. I think it's important in focusing on this case to note what appellant is not arguing. They're not arguing that the comparative fault instruction was improperly worded, and they're not arguing that there was any errors in the admission of evidence. And so based on the evidence that was presented in the case and based on what was a correctly instructed jury, if it should have been instructed on comparative fault, what was the result? A unanimous verdict allocating 95% fault to the plaintiff, number one. And number two, Judge Gama, after being asked to review it on a motion for new trial, finds that there was, quote, substantial evidence presented to support the jury's allocation of fault. So the people who were in this 3-week trial, listening to all the evidence, watching the witnesses, seeing the videotapes, looking at the photographs, unanimously concluded, both the judge and jury, that there was A, fault on plaintiff's behalf, and B, that the allocation of fault was appropriate. And let me suggest to you that that is absolutely borne out by the record. Appellants frequently say that, well, the defendant didn't argue really strenuously about the comparative fault of plaintiff in this case. There is a difference between what the argument of counsel is and what the evidence is. There was certainly sufficient evidence to support comparative fault. The thrust of the defense in that case, in our case, was primarily that there was no negligence on behalf of BNSF, but that there was evidence, if the jury wished to go to negligence, that supported an allocation of fault to plaintiff. The Budinsky case, and thank you, Judge Gould, for being the first to say it, is a case directly on point here. It is a relatively recent 2010 First Circuit opinion that raises exactly, frankly, the issues that are raised here. It is a case from appellant's own brief, and that was one of the arguments raised. Well, defendants really just focused on the lack of negligence of the defendant and didn't really focus on the comparative fault of the plaintiff. And the court there rightly said, that's a tactical choice that a party may make in terms of how they argue the case, but the evidence was there to support the jury's finding, and that's the case here. We believe that the verdict here should be sustained for two reasons. First, there was sufficient evidence to justify a comparative fault instruction, and secondly, we don't believe that plaintiff properly preserved its right to appeal the comparative fault instruction here. I want to first talk about the evidence that was there in support, but let me make a general observation. The reason I submit to the court that plaintiff didn't properly preserve the objection to the comparative fault was because everybody knew comparative fault was in the case. And that's why there was no strenuous objection and no argument that they're able to point to relating to the inclusion of comparative fault, and why in truth and in fact, as Judge Swan noted, counsel for the plaintiff suggested language and that was actually included in some of the comparative fault instructions. So that's a complete waiver. And let me remind the court that there were a lot of questions to appellant about the inferences and which way the inferences should go. In this case, all inferences that can be drawn in favor of the verdict should be drawn in favor of sustaining the verdict. And we think the inferences here clearly support the conclusion that there was comparative fault by plaintiff.
What's the strongest, if you were to argue the inference against plaintiff on comparative fault, the best you could, what's the strongest inference there is from the evidence?
The strongest, well, I think the inference would go like this, Your Honor. First, that plaintiff had performed this act and walked on ballots throughout his career. He admitted that he did so daily. The evidence was very strong that people are trained how to walk on it, that there's no problem in walking on it, that it's a reasonably safe working surface, and that evidence was presented at the trial.
Assuming that crushed rocks are universally consistent over the course of thousands of miles.
I'm sorry.
It is a safe surface. We're not talking about a rubber mat here. We're talking
No,
about
we're talking about
variable
we're talking
surface.
about ballast, which is an aggregate material. It's a structured material that is compacted and that people walk on. But this location had been looked at and inspected by both plaintiffs' experts and by defendants' experts. Everybody agreed that it was in a great shape. It complied with all regulations. The jury actually saw a videotape of plaintiff's expert walking backwards with a notepad in his hand at the accident scene, which sort of, I suspect, made the jury disinclined to believe that this was a particularly difficult task or an unreasonably dangerous one, and led to the argument during close that I hear what they say, but I see what they do. But I would go further than that in terms of responding to your question, Judge Swan, is that we had specific testimony from Roy Dean, who was an expert for the defendants. He was the former head civil engineer of one of the nation's 4 largest railroads, and he testified as an expert, and he talked about training that all employees get, and they have to make sure that when they're walking on ballast that they have firm footing, and that ballast may move. But he testified, I'm going to quote here, even if ballast does shift a little bit when you step down, if you let it shift, it will provide you a firm foundation. Once you get that, then you can pick up your other foot and transfer your weight to that foot. That's a quote from Roy Dean. He then said, in response to a question from Mr. Petru, well, did Mr. Davis fall because ballast shifted? And Mr. Dean said, quote, no, well, because he didn't have his feet secured before he took a step. So Mr. Dean, the expert, is saying he's trained not to move his feet until he's secure, and that the reason he fell is because he apparently did not have his feet secured before he took the step. That's consistent with the testimony of the other witnesses, Bossart and Ritchie, that this is perfectly safe to walk on so long as you watch what you're doing and walk slowly and firmly. The jury was the jury was aware that he was only 4 feet away. He was going to traverse a very short distance. The slope was not significant. It was not a difficult task. They saw pictures of the location. They understood the situation. They had lots of testimony about the training that was given, and they obviously drew the inference that the reason he fell, he wasn't taking reasonable care for his own safety. So that was a very long answer, but there was a whole lot of evidence that supported the 95% allocation, to be honest. One of the things I wanted to touch on briefly is that they, in some fashion, and I don't know that they're continuing to ride that horse since they didn't say it here, but they somehow claim that because BNSF didn't cite him for a violation of a safety rule, that somehow is a concession that he wasn't comparatively at fault. We've cited the case that say that that's not true. First of all, the statement there's a law dead on point that says just because you didn't violate a safety regulation doesn't mean that your behavior is otherwise blameless, and that you've wholly complied with the standard of care applicable to all the activities you did at the time of the incident. And secondly, if you look at the testimony they quote in support of that, it's from Mr. Kreger, and all he says is he doesn't know whether the fellow violated a safety rule or not, and there's certainly no suggestion that he did an investigation into exactly what this fellow did or whether there was ever charges brought against him for a safety violation. That's a non-starter. And what's certainly clear here is that this was a well-instructed jury that understood fault and its allocation by virtue of the questions they asked the judge about exactly how does the allocation of fault work here. One thing I need to touch on is simply the low level of proof that is required to find negligence under the FELA, and that is borne out by the jury instruction that was given them that correctly states the law. But it says that an act or mission that plays any part, no matter how small, in bringing about an injury is a cause of such injury. So the no matter how small part is, the negligence can be this much. There's a suggestion in the case law maybe less than in some other kinds of tort, but that can be enough to establish negligence under the FELA. And so this is not a case. This is a case where, frankly, they're not up here saying that there was a whole lot of negligence on behalf of BNSF. This is a case where there was 5% according to the jury negligence, 95 according to plaintiff, but there was no egregious conduct by anybody anywhere. There was no suggestion that this condition was anything other than normal and reasonably safe, at least as supported by the evidence. But let me turn finally, in the time I've got remaining, to whether plaintiff complied with Rule 51A in the first instance, because as Judge Swan said, yes, indeed. I'm going to submit to the court any fair reading of what went on in front of Judge Gama is that plaintiff completely waived any objection to the comparative fault instructions that were given, and that in fact plaintiff was was as much the author of those instructions as anybody else if you read through the transcript. And the sort of casual observation at one point that he says, I don't think that this case, the comparative fault should be in this case, is hardly a straightforward objection to a specific proposed instruction. It's not. And the record doesn't show that. And the proof of the pudding is this: on two separate, in their opening brief and in their reply brief, plaintiffs never give you a cite where there's a specific conversation about, I object to giving this comparative fault
I don't
instruction.
agree with you on that, counsel. I think it's confusing. I do see where later on counsel submits a comparative fault instruction. So, but I mean, they do say, I'm citing from the record here, frankly, we had submitted a jury instruction indicating in this case there's no comparative fault. For the record, I do not believe that there is any evidence that Mr. Davis was negligent in any way, shape, or form. In fact, there's no testimony from his managers that he's committed no rule violations, and I don't think a comparative fault instruction should be given. That's an objection. I don't know how else to take that. I mean, if counsel would object to instructions when I was a trial judge, I would have taken that as an objection. What is confusing is then, right on the heels of that, they submit an instruction and say, I wouldn't have any objection to this, and then they give you instruction.
Right, and that's what goes on, and I think that's, quite frankly, Your Honor, the way Judge Gama took that as was a preliminary observation, just much as me say, I don't think that there's any fault here at all, but let's go ahead and discuss I don't think there's any fault here at all because your expert said that my client complied with all federal regulations relating to the structure of the track. But let's go ahead and discuss the jury instructions, okay? And then I start agreeing to things. Well, I've waived it. I don't know that's quite putting the judge. Remember, part of the reason we have 51A is so the trial judge can really focus in on, are these proper instructions and is this a proper way to go? And the record does not reflect that Judge Gama was ever given that opportunity either then or in the new trial motion where they didn't even raise the issue of whether the court had properly instructed or appropriately instructed on comparative fault. That was not even an issue that was ever presented directly to Judge Gama for resolution. And I don't think that's consistent with Rule 51. And I think that what the record shows is repeated and consistent waiver of any, if it was sufficient, Judge Gould, to be an objection initially, I think it was absolutely waived in the 50-page conversation that follows, where they repeatedly and consistently approve of language and suggest language about how comparative fault should be applied in this case, including the language that was actually submitted to the court, to the jury.
Do you disagree then that fundamental error review should be applied if in fact the objection to the instruction was waived? Do you think that that's the end of the matter, or that this court can then look at whether it was fundamental error to give the comparative fault instruction?
Well, I know that the teachings of this court and the Supreme Court has been that fundamental error is rarely used in civil cases. And there is nothing, quite frankly, about the evidence in this case, the facts of this case, or the instruction that was given that I would think goes to the fundamental error issue. I just don't see it that way. Unless there's any further questions, I think I said what I had to say, Your Honor. Thank you.
Counsel?
Thank you, Your Honors. I realize I have very limited time, so I'll try to move very quickly. I think the key point I want to get to here is the jury instruction objection. Judge Gould, I appreciate you pulling out the text from the record. There was indeed an objection. It was clear. It was supported. It was either ignored or overruled, but it certainly wasn't granted. And what counsel then suggests is, if you kind of play this out, is if you were to rule that objection is then overcome by the fact that plaintiff's counsel participated then in the crafting of the language of the rule that was given over his objection, then what plaintiff's counsel should have done is refused to participate in making sure the rule was correct and invited further error. That clearly can't be the rule for trial practice. What counsel did was objected, said we should not give this instruction. When the instruction was clearly going to be given, counsel said, well, let's make sure we get it right.
But they shouldn't have said, I have no objection.
It was poorly chosen language in the midst of
Trial
it.
judge to do, counsel. I have no objection to this instruction.
I assume the trial judge should have understood that he had no further objection to it. But I understand the language is unfortunate, but clearly there was an objection to the giving of it. Let me just briefly touch on one other item. There was significant, substantial, and uncontroverted evidence that people fall on ballast, that ballast shifts under their foot when they're being as careful as possible. It came from BNSF's managers, it came from BNSF employees, it came from Mr. Davis, it came from Mr. Craig, it came from track inspectors. So the idea that there's an inference that can be made that, well, if you're walking on it and it falls, you must have done something negligent is simply not supported.
It's not whether the ballast shifted because of his negligence, it's whether he handled the shift in an appropriate way.
I don't recall from the record saying, I recall the record saying that ballast shifts. I didn't recall reading anywhere that people fall all the time because ballast shifts. Is that the record?
There's no record where that specific, the people fall all the time. There was, I believe, it's either Mr. Gilliam or Mr. Ritchie. I'm getting the two track inspectors confused in my head, but one of them said, sure, it shifts under my foot all the time, and it says, even when you're being as careful as possible, yes, when I'm being as careful as possible, and you lose your footing, yes, I lose my footing. Now, does that mean he falls to the ground? Not necessarily, but certainly if you lose your footing, that is the potential next step. I realize I've already gone past my time. Thank you, Your Honors.
Thank you, counsel. All right, counsel, we'll take this matter under advisement. We'll issue a decision in due course. Court's in recess.